The jurors speak. Right from the horse's mouth, this New York Herald article is as good as any other found following the jury's verdict of second-degree murder and their reasons for arriving at that decision. One or more articles surfaced before the trial's end which hinted at jurors feeling pressured. This article addresses that rumor and other issues. Unlike today, New York juror names and addresses could, on occasion, be found published in newspapers as well as their likenesses with accompanying names. In this trial, their places of business were likewise listed. The jurors were permitted to read newspapers. On one occasion they sat comparing their likenesses to their actual features. One Philadelphia newspaper, Philadelphia Inquirer, July 12, 1891, was extremely critical of the trial and result when it was learned that the jurors hadn't been sequestered and were able to go home after each session. The Times reporter said that this would make every Philadelphia lawyer throw up his hands in horror at that revelation. Different states had different protocols. This is an excellent, if not the best, article to gauge the emotions and judgment of the 12 men who served on the jury. It is also one of the best articles ever written about case-related events in my opinion. New York Herald. July 5, 1891. Views of the verdict in Ben Ali's case. Even the events of the glorious Fourth. Hardly a more absorbing topic for general discussion. What the jurors say. Mr. Rutsky denies that he meant to imply that any of them reached their conclusions from other than their best judgment. It was the supplying of a motive that decided them. A formal statement. Aside from the incidents of Independence Day, and to many persons more interesting even than the events in which they took part, but one news topic was generally discussed yesterday: the verdict of murder in the second degree in the case of Amir Ben Ali, or Frenchie, for the killing of Carrie Brown, Old Shakespeare, in the East River Hotel. Surprise was generally expressed, not that a verdict of conviction was found, but that it should be for murder in the second degree only. There was a division of opinion as to the guilt or innocence of the prisoner, but most of those who believed in his guilt were inclined to think him guilty of a cold-blooded, diabolical crime, as shown by the horrible mutilation of the old hag's body, and that murder in the first degree would have been none too severe a judgment. No outside influence. As to the statement attributed to juror number 8, Samuel Rutsky, note, his surname was Rutsky. H.B., of number 57 91st Street, from whose refusal to discuss in detail the occurrences in the jury room and the fact that he at first held out for acquittal, it was inferred that he was withholding information that might be important. I became convinced, after a thorough investigation, that his utterances had been misconstrued. I not only talked at length with Mr. Rutsky but also interviewed a number of the other jurors. All of those whom I saw agreed that such a view of the jury's work as that implied by the construction put upon Mr. Rutsky's remarks was utterly false. Mr. Rutsky himself denied in the most emphatic terms that he had meant to create any such impression, to wit, that the verdict was not reached with the utmost honesty by each of the 12 and without interference or any outside influence. He denied that he had made any remark that could possibly be so contorted. Asked about the importance attached by the jury to the various portions of evidence, Mr. Rutsky said to the majority of the jurors that the evidence of the medical experts for the prosecution furnished the chief argument for conviction. Mr. Rutsky himself, however, was influenced by this medical testimony to a much less degree. He considered that it was to a great extent offset by the statements of experts for the defense. Saw a motive at last. What was it, then, I asked, which decided you to vote for conviction? It was the chain of reasoning by which the district attorney showed, to my satisfaction, at least, that Frenchie could have had a clear motive for the crime. Until that was demonstrated, I considered everything else as more or less immaterial. My sympathies, based on the evidence, were with the prisoner all along, until then. I wish, however, emphatically to deny ever having spoken of this unhappy Arab as being little better than a beast. An evening paper very unkindly put those words in my mouth. It is a terrible thing for one man to find himself in a jury room with 11 men dead against him, men whose judgment and capacity he has every reason to respect. That was my position. I said to myself. It cannot be that these gentlemen are all wrong in their conviction and that I alone am right. So I reasoned at the time, but after all, I don't know. I am beginning to think that one man may be right and 50, yes, 500, who are against him are all wrong. Feeling thus strongly caused me to show great excitement and emotion when a reporter interviewed me late last night, and was doubtless the cause of his misunderstanding what I desired to say. A composite statement. Mr. Joseph Bartels, the foreman of the jury, was very much surprised at what Juror Rutsky was reported to have said. Of course, he denied that there was a particle of truth in such an implication. Mr. Bartels had had a conference with jurors Niemann, Boom, and Waterman, and Juror Boom had been empowered by them to make public a statement of what actually occurred in the jury room from the time they left court until the verdict was reached. Mr. Boom was very indignant over the statements attributed to Juror Rutsky. After expressing his indignation he said, "Behind the scenes with the jury. This is what occurred in the jury room and this is what I am requested to tell. The first thing we did after retiring was to take a ballot on the question of guilty or not guilty without entering upon the 4 degrees of guilt, that is, 2 of murder and 2 of homicide. The result of this verdict was 11 guilty and 1 not guilty. This ballot was cast by Mr. Rutsky. We then asked him to explain the reasons that led him to the conclusion that Frenchy was innocent. He got up and spoke, I think, for almost 10 minutes. I think I do Mr. Rutsky no wrong when I say that his remarks did not weaken in the least the opinion of the 11 jurors that Frenchy was guilty. The points he raised were these: first, that it would be unfair to convict any man of the murder until the man who was with Shakespeare on the night of the murder had turned up and his innocence of the crime satisfactorily proven. In the second place, he claimed that the evidence of Dr. Paul Gibier completely disproved the evidence of the prosecution based on the investigations of Drs. Edson, Flint, and Fermad. Mr. Rutsky seemed very much excited while speaking. When he stopped I asked him whether he had fully stated all he had to say, and he replied that he had. I then spoke to him for about 20 minutes, running over the evidence that had compelled me to come to the conclusion that Ben Ali was guilty. Counter-arguments. I asked Mr. Rutsky to put himself in the place of the man who retired on the fatal evening to room 31 in the 4th Ward Hotel with the woman. I showed him that very few men on reading in the newspapers of the murder would have come forward and said, "I was the man who last saw the woman before she was murdered." Few men have so lost their self-respect as to come forward and confess to such depravity. Then I dwelt on the standing of the microscopic experts for the prosecution. They did not say that the blood was human blood on Frenchy's fingernails and upon the front of his shirt was identically the same as that found on the bed ticking upon which the dead woman was found. And then the clinching argument, as far as the blood test was concerned, is the fact that the blood on the back of the shirt, near the wound which Frenchy said he received while in the army, did not display any of the characteristics of other blood stains. There were 3 blood stains emanating from 2 different sources on the person of the prisoner. One came from the prisoner's own wound, the other flowed to my mind without question from the gaping wounds of the unhappy woman. Frenchy as a linguist. Then I dwelt upon the behavior of the prisoner on the stand. The papers can talk as much as they please about Recorder Smith's charge, but that had nothing to do at all with convicting the prisoner. It was Frenchy's own attitude and demeanor on the stand that by convincing us of his guilt convicted him. How the man lied. Why, he understands French perfectly, and the Arab interpreter was merely a picturesque embellishment. More than that, he understands English quite well. I am convinced that there was not a direct question put to him in English which he did not understand immediately, long before the complicated interpreting machinery had been put in motion. Why, I sat near him and I, myself, heard him inquire of his counsel in an undertone, which was not so low as it was intended to be, "Which basement do they mean?" Then I took up Mr. Levy's plea that the crime must have been committed by a left-handed man and completely disproved that to the satisfaction at least of the jurymen.
Juryman Phillips took out his penknife and I placed myself in a prostrate position up on the bench in exactly the same position that Shakespeare was found in. Juryman Phillips then manipulated his knife in a fashion that showed conclusively that a right-handed man could have inflicted the wounds found on the body of the woman as well as, in fact, better than, a left-handed man. A bad witness for himself. His behavior, when confronted with Nellie English, the woman who had been with him in the Fourth Ward Hotel several months before the crime was committed, and who testified as to the manner in which the Arab crept around the corridor peeping into the rooms, showed that he knew well that her evidence was very strong corroboration of his guilt. It showed that he knew the intricacies of the crooked corridor well, that he could find his way about without a candle, and that he was in the habit of peeping into the bedrooms, for what purpose we do not know, but surely for no good purpose. When I got through, Mr. Rustsky said he was convinced after all the man was guilty, but that he did not feel certain enough of it to hang. But I think now that he is a danger to the community and that we ought to send him far, far away. Rutsky added. I then asked him whether Sing Sing would be far enough away, and he said yes, he thought it was. We then took another ballot on the question of guilty or not guilty. The result was unanimously in favor of conviction. We then took a ballot on whether the crime was murder in the first degree or not. The result was 6 for and 6 against. We then took a ballot on the question of murder in the second degree, and the 12 jurymen rendered this verdict and that was the end of it. The jury was not afraid. You may be quite sure that we gave an honest verdict, and there was no attempt to tamper with or bulldoze the jury from any quarter whatever. We went into that box to render a verdict of all the facts and we were no more afraid of this recorder, Inspector Burns, or District Attorney Nickel than we were of Mr. House or Mr. Friend. Since last evening the large majority of friends whom I have met and who have called upon me seem to think that Frenchy was innocent. All I have said to them was that they were not in the court throughout the trial and had no absolutely reliable data upon which to have an opinion. Mr. House will appeal. We shall certainly appeal from the verdict against Amir Ben Ali, said Frederick B. House, of Ben Ali's counsel, to me yesterday. We feel absolutely certain that the general term of the Supreme Court will set aside the judgment and grant us a new trial on the ground that the verdict was absolutely inconsistent with the law and the evidence, that it was impossible rightly to convict Ben Ali of murder in the second degree. He is innocent. If he were guilty of the atrocious butchery of old Shakespeare, he would have been guilty of murder in the first degree. The verdict is farcical. Why are you so confident that the judgment will be set aside? I asked. Because incompetent testimony was admitted, and because Recorder Smythe's charge bore directly against the defendant. When Ben Ali has been sentenced to state's prison for life next Friday we shall formally ask the recorder for a new trial. This, of course, will be refused. Then we shall serve notice of appeal. We shall go before the general term of the Supreme Court in October, I hope, and I have not the least doubt that a new trial will be ordered. Ben Ali cheerful. Amir Ben Ali was like a new man yesterday. The suspense was over. His life was safe. He was well fed and well clothed and had a good roof over his head. It was the tomb's roof. Will I hang? He had asked the deputy sheriff who took him back to the tombs. You will not hang, said the deputy sheriff. Good, said Ben Ali. When he awoke yesterday morning Ben Ali was returned to cell number 63 on the second tier. Tombs etiquette requires that the gentlemen who sojourn there shall not sleep higher than the ground floor whenever they stay out after 9 o'clock at night, so if Frenchy had but known it he spent the night in a condemned cell. He was up bright and early. After he had been returned to cell no. 63 he prayed to Allah and then smoked a long black cigar lawyer friend had given him.